I'm Dave Dinkle. Are double closings legal in North Carolina? Attorney closed state explained. Double closings are legal in North Carolina, but they're not automatic. In this video, I'll explain how attorneys evaluate same-day closings and why some get approved while others don't. If you invest in real estate in North Carolina, you've probably heard at least one of these statements. Double closings are illegal in North Carolina. Attorneys don't allow that here. You can't do same-day closings in North Carolina. None of these statements is accurate, but they're not completely wrong either. Double closings are legal in North Carolina, but they are not automatic, and they are not investor controlled. Whether a double closing moves forward depends entirely on attorney review, structure, and timing. In this video, I want to explain what legal means in an attorney-closed state like North Carolina, why some double closings are approved and others are rejected, and what investors misunderstand about how these decisions are made. This is not legal advice. This is a procedural education so you understand how North Carolina closings actually work. Let's start with a simple answer. There is no law in North Carolina that prohibits double closings. There is no statute that says an investor cannot buy a property and resell it the same day. There is no blanket rule banning same-day transactions. So when somebody says double closings are illegal, what they usually mean is the attorney I spoke with won't approve the structure. Those are very different things. In North Carolina, legality does not equal approval. This is where investors get tripped up. In many states, the question is this allowed by law? In North Carolina, the real question is, will the closing attorney approve this structure? Because closings are the practice of law in North Carolina, attorneys are not just checking legality, they're evaluating ethical responsibility, fund flow clarity, disclosure risk, professional liability, whether the structure is defensible. An attorney can legally say no to a deal that is technically lawful if they believe it creates risk. That's why arguing legality with a closing attorney is usually a losing strategy. A double closing in North Carolina is not a trick or a workabout. Procedurally, it means there is an A to B purchase, there is a B to C resale. Both are separate transactions. Each has its own purchase contract. Each has its own settlement statement. Both are scheduled for the same day. From an attorney's perspective, this is two closings, not one deal with a shortcut. When presented clearly, that structure is not inherently problematic. North Carolina attorneys approve double closings when they believe the structure is transparent, the end buyer is real and ready, funds move in a clear sequence, nothing remains outstanding after closing. Settlement statements accurately reflect prices. No party is misled. When these conditions are met, many attorneys are comfortable handling same-day transactions. This issue is not the concept of a double closing. It's how often investors present them poorly. This is our website, besttransactionalfunding.com. Menu tab has our contact phone number and contact email readily available. Also, you can see our proof of funds. While you're on the website, check out our products tab where we have available specific ebooks immediately deliverable for problems investors encounter every day. In addition, under our About tab, you notice we have investor-friendly agents listed state by state, so it saves time looking for closing agents who are investor-friendly. That's besttransactionalfunding.com, 954-274-1003. Now let's talk about why deals get rejected. Attorneys in North Carolina often reject double closings when they see vague explanations of profit, investors trying to hide information, no identified end buyer, delayed B2C closings, confusing fund flow, we'll figure it out later timing, language that sounds evasive. From the attorney's perspective, they aren't business decisions, they're risk indicators. Remember, the attorney is personally responsible for how funds are handled. One key distinction in North Carolina is same-day execution. Most attorneys are far more comfortable with A to B and then B to C on the same day than with A to B today and then B to C tomorrow. Why? Because overnight holds raise questions about who owns the property, who is exposed to risk, whether funds are being improperly bridged, whether disclosure issues arise. This is why many North Carolina attorneys will approve same-day double closings but reject delayed resales. This is important. In North Carolina, double closings are not used when there is no end buyer. The resale is uncertain. Funds need to stay outstanding. The deal depends on future events. The investor wants to test the waters. If any of these apply, most attorneys will not approve the structure. Double closings are viewed as execution tools, not speculation tools. This deserves its own emphasis. Two investors can describe the same deal in two different ways and get two different outcomes. Saying, "This is structured as two separate closings scheduled for the same day," is very different from saying, "We're flipping it right away and need funds temporarily." Same transaction, completely different framing. Attorneys are trained to respond to structure, not strategy. Many investors try to argue approval by comparison. You can do this in Florida. This is normal in Texas. Michigan allows it all the time. That argument does not work in North Carolina. Each attorney evaluates deals under North Carolina professional responsibility rules, not national investor norms. What matters is North Carolina ethics, North Carolina escrow rules, North Carolina liability exposure. Comparisons do not reduce risk for the attorney. So why does the myth that double closings are illegal in North Carolina persist? Because it's easier to say they're illegal than to explain they're legal but frequently rejected when structured poorly or explained incorrectly. Most investors never get past the first rejection, so the myth spreads. If you're investing in North Carolina, here's the correct mindset. Double closings are legal. Approval is discretionary. Attorneys decide, not investors. Structure and explanation matter. Same-day execution is critical. When you approach these deals with that understanding, your success rate changes dramatically. besttransactionalfunding.com 954-274-1003